Yes.
May I mention item number 16, madam?
16.
Yes, 16, madam. And madam, the other party is supposed to be on the online. She's Delhi-based lawyer, madam. And yesterday I spoken to him for madam the taking adjournment, and the consent was given, and he was also given the consent for madam, 4 weeks time to file affidavit, and another 2 weeks time may be granted for filing reply to the affidavit in opposition filed by me, madam.
Okay, what is this criminal petition about?
Madam, the costing of madam, the FIR as well as charge sheet money.
Then why affidavits are required?
Madam,
FIR quashing or charge sheet quashing should be based on the material
Madam.
already collected.
But madam, there are certain documents and certain things which has not been covered up in the madam, the entire things. So therefore, being a complainant, madam, they can complain.
On the prayer of the learned counsel for the petitioner, matters item number 16.
Madam, item number 16, madam.
Matter stands adjourned
For 4 weeks, madam.
for 4 weeks. In the meantime, the parties may exchange their pleadings.
Madam.
And do you want any specific date?
No, madam, 4 weeks time.
Okay.
That's all right, my lord.
Your Lordship, may I please? I would like to mention one unlisted criminal petition for today as the last item number.
Not last item. You bring it, we'll take it up. No
Okay,
problem.
much obliged.
What is the urgency?
Because there is
This is a 2012 old case, Your Lordship, and the trial is on Monday, Your Lordship. There's a petitioner are from very interior place of Arunachal Pradesh.
Now, what do you want in that petition?
This is a criminal petition. I need some
The petition is challenging?
challenging 380.
No. Challenging charge sheet,
Challenging charge sheet as well as the FIR. It's a charge sheet.
Lords, my apologies if I may intervene. I'm for the petitioner in item 16. The connection got disconnected. Lords, my
yes.
learned colleague Mr. M. Kato has taken time to file a reply. Lords, I only seek that a rejoinder time be given to me. And Lords, there is an interim
Therefore,
order.
we have given 4 weeks time. In the meantime, parties to exchange
Please,
pleading.
my lords.
Please.
Please, my lords. My lords, the interim order granted earlier may continue for the
Okay.
next day.
Interim order passed earlier shall continue till the next date of listing.
Deeply obliged. Deeply.
Lordship, I beg to mention item number 10. This may be taken about 2 weeks, Lordship.
Why this matter is listed? These are orders or okay.
Supplementary hearing, Lordship.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 2 weeks.
Highly obliged.
Any interim order?
Hearing-
Yes, silo. Yes.
Wait, please, Lord. Lordship, I beg to mention item number 6.
Item number 6, yes.
I am for the respondent number 2 here in Lordship.
Yeah.
Have taken consent from the business side, Lordship. This matter may be kindly taken up after
On the prayer of the learned counsel
3 weeks.
for the respondent, matter stands adjourned and be listed after
3 weeks.
3 weeks.
Mayor, my lord, I beg to mention item number 25.
Item number 25.
Yes, on behalf of K lawyer, counsel is out of the station, so
On the prayer of
we are
counsel for the respondent.
no here. Yes,
You are for the petition appellant or
the
respondent?
respondent. my lord.
Respondent.
Yes,
On the prayer of the learned counsel for the respondent, matter stands adjourned.
matter may list after 3 weeks.
After
3 weeks.
3 weeks.
My lord, I beg to mention item number 2 also.
Item 2,
Yes,
yes,
same order, my lord.
same order.
And there is an interim, my lord.
In item 2, interim order passed shall continue till the next date of listing.
Much of that.
My lord, I beg to mention item number 27.
Item number,
27.
yes,
Matter may be adjourned for the same may be list after 3 weeks.
you are for the appellant.
Yes.
When?
After 3 weeks, my lord.
After 3 weeks.
And my lord, there is a interim order.
Interim order passed earlier shall continue till the next date of.
Much.
Yes,
I beg to mention item number 8, my lord.
item number
8, my lord.
8.
With consent of other side, my lord, may I pray this be listed for 2 weeks, my lord.
After 2 weeks.
No, it's after.
You are there.
Yeah, I will.
After 2 weeks.
Interim order, my lord, may be kindly continue.
Incremental partial shall consider till the next date of listing. I have dealt with this matter earlier, or name is very familiar.
No, but that service matter was.
Service matter, my lord.
That was taken to Supreme Court finally and then transfer posting matter. My lord,
Okay. That somehow this name clicks my mind. Somehow, oh, that transfer method.
right.
Okay.
Obviously.
What is the issue here?
Issue, my lord, we are challenging, my lord, FIR and a charge sheet, my lord. Obviously.
Your Honor, I beg to mention item number 13.
One,
Item number 13,
one,
1-3.
three. Okay. You have the petitioner?
My senior, Mr. Mukherjee, is out of station.
S. Tapin.
Mukherjee.
So you are for the respondents, meaning. that-
Yes.
Okay. Respondents, 3 weeks.
Deeply obliged.
Your Lordship. I beg to mention one pending matter, Your Lordship, for listing.
Unlisted matter,
No, pending matter,
pending matter.
Yes.
When?
tomorrow.
What is the subject matter?
CRP.
Service is complete?
Sorry, not CRP, CRL matter, Your Honor.
Uh-huh.
CRL matter. Oblast.
Yes, my lord, I beg to mention item number 7. For the petitioner, I'm for the petitioner. My lord, main counsel is out of station. So matter may
At the
wait
end of the day, you want an adjournment. Allowed. When?
after 3 weeks.
3 weeks.
Obliged.
No, my lord, after a long time I make.
Yes, what is the issue here?
My lord, the fact is, the petitioner number 1 and 2. It's a joint application under 5,
What is the affair?
FIR, my lord, is at page 21.
Page 21. Anything type copy of this affair? Very small handwriting.
Type copy.
You have not typed this. Page 22.
Yes.
Very difficult to read.
Complaint is at,
Huh?
Annexure 1, my lord, kindly copy page 18.
Page?
18.
Okay.
Both of them are adult, my lord, were in a relationship. Then the petitioner was, number 1 got pregnant, and in the meantime, the petitioner number 2 says no. Business. And then finally, my lord, there was a bail application filed. And then if the petitioner number 2 says that no, I'm ready to forbear the father of the unborn child in the womb of petitioner number 1. My lord. So then what had happened was, thereafter they executed a marriage, they have solemnized as per Mompa customary law. So now they are living together.
Now, what is the present status?
Present, it's both of them are living together. They were solemnized as per Mompa customary law. My lord.
Where is that? Page? Any agreement?
Page 54. My lord.
Page 54?
Yes.
57?
50, it starts from 54. My lord.
Okay, 54. So in a sense, they are married now.
They are married now. My lord has already dealt in that this Navam Yari judgment. My lord.
Hard. Yes. Mr. Tara, Learned Counsel on the position. Also heard Mr. G. Taro, Learned Edition, Public Prosecution. First,
My lord will refer to my lord's judgment only.
we will not refer to, we'll shorten it, 2 pages will close it. The present application is jointly filed by the petitioners who are now husband and wife.
Correct.
And got married under the traditional custom of
Mompa customary.
Mompa clan or caste tribe. Mompa tribe. From the reading of the affair, which was lodged by the respondent number 2,
One. Petitioner number 1.
Petitioner number one. It is seen that the fundamental allegation is that both the petitioners were having a long-standing affair, and petitioner number 1 became pregnant. However, the petitioner number 2 refused to marry her, and accordingly the affair was lost. Full stop. It is also on record that it is also on record that in the meantime they got married and staying together as husband and wife. Full stop. In view of the aforesaid, in the considered opinion of this court, it cannot be said that any offense under what is the registered 376?
376.
That any offense under section 376 is made out inasmuch as since marriage has already been solemnized, there cannot be any reason to say that there was a cheating on the sitting on the part of the petitioner also. Therefore, in the totality of the matter, stands alone.
Much. Para 17 के detail আছে না? Much obliged.
In this case, I have received this civil revision petition copy today on the matter. Matter may come up after 4 weeks only.
Today means
Today.
only today.
That is because my lord, after the case is done, my London press goes off. I can hardly see it.
What is the issue here? Okay, issue. We have been very liberal here, granting time.
The order of the FTC, my lord, in dismissing the money suit number 01-2007.
The suit has been dismissed. Now, why civil revision?
My lord, this was
It
filed.
was dismissed for what?
It was filed before the, my lord, first track court, my lord. He was exercising powers under the Assam Frontier Regulation.
Okay,
For revision lies.
okay.
That was the objection taken in the IA, my lord. IA was, my lord, condoned for 4,625 days on 24/6/2024 only, 2 months back. And on that day itself, the notice of motion was issued by this honorable court, and the copy was directed to furnish to me, but it was.
What is the entry in order?
My lord, I will be needing time to.
No, just I
Yes,
want
yes,
to
my lord.
understand. Well, we'll give you an adjourned. since
Yes,
there
yes,
is
yes.
No problem on that, but I want to understand what is the issue here.
The suit was finally disposed of.
Suit was filed for
For
realization
realization
of money before.
Before the additional district and session judge, page 69 it is there.
Under what provision? Frontiers.
Yes.
In the frontiers, it is given that the power is given to the.
No, my lord, the folded, my lord, with the help of the government will be required. Their appointment was under the planning for regulation. I am certain of that, because it is recorded with some judgments also.
Okay.
They will confer the powers and.
Okay, Mr.
additional-
Singh, Learned Counsel appearing for the Food Corporation of
Food
India.
Corporation of India.
Corporation of India seeks an accommodation as he has received the copy of the civil revision petition today only. Prayer is not opposed by Mr. Pangi. Accordingly, prayer stands allowed. Please this matter on.
After 4 weeks, ma'am.
No, it is for you. It should be a date.
Yeah, yes, ma'am.
Because you're an outstation council.
My lord, on 22nd November.
22nd of November, 22nd of November.
Oblige.
Lordship, matter may be passed over for timing, Lordship.
Timing, what is the issue here?
My lord, they have challenged an order of the deputy commissioner by which the appeal against the decision of the village authority was dismissed. Otherwise, the whole petition is misconceived.
Any stay? No stay.
No, I don't have the brief, Lordship.
Okay, who is the council? Okay, we'll wait
B-
for.
BP
Yes,
change.
wait
my
or
lord,
we'll
yes.
adjourn, wait or adjourn.
No.
My lord may wait, it will not even take 10 minutes.
Okay. We'll call it again. Yes, what is this revision by state?
Your lordship is challenge the discharge order.
Challenge the discharge order.
Yes, your lordship.
Service is complete.
Yes, your lordship.
Who is representing?
Perhaps the name is reflect that we have in fact
Name is
filed the your lordship additional affidavit bringing on the record the completion of justice service as well, your lordship.
No, his name is shown. Who is this lawyer? CW.
He's
Or-
outstation lawyer, your lordship. So in that case, your lordship, this matter may be fixed after 3 weeks. Otherwise, your lordship, this case is related to SIT case, and SIT have their own special PP, your lordship.
What is the offense? Can you kindly see the FF?
Yes, your lordship. It's a mob lynching case, your lordship.
Huh?
Mob
Mob
lynching case,
lynching.
yes. The under trial prisoner has been.
All discharged.
Yes, honor discharge.
The present revision petition is filed by the state. Assailing order of discharge dated was
13/5/22, your lordship.
13.
5/2022, page number 18, your lordship, may kindly confirm.
Order dated 13 to 2018.
Yes,
No, no.
13/5/2022.
13/5/2022. Passed by the learned session Judge Teju. Full stop. Though name of the respondent, name of the counsel for the respondent are shown in the cause list, however, none appears from them. Therefore, in the interest of justice, though matter stands adjourned and be listed and directed to be listed on give a date after 4 days.
On 13th, your lordship, November 13th.
13th of
Yes,
November,
yes.
13th of November 2024. However, it is made clear that if none appears for the respondents, matter may be taken up on the materials available on record.
Yes, sir.
Please
Deeply
record.
honored. Deeply honored.
Yes,
Lordship, here is, the question is whether, Lordship.
Hmm?
When any execution petition, Lordship, that's that, Lordship, petitioner is there, I am for the respondent, Lordship.
okay, what is the issue here?
Issue is whether in execution petition, Lordship,
Hmm.
the third party can object the executing petition, Lordship.
Hmm.
For my understanding, Lordship, third party can file objection petition, Lordship, under order 21 rule.
Third party can file objection, no
yes,
doubt about it,
Yes,
but in under certain circumstances.
Yes,
Suppose a decree is passed without making a party
yes, Lordship,
something, so it should be treated as a fresh suit and it can proceed, no problem on that.
yes, Lordship. In this case, Lordship, I am not the party, Lordship. The degree was
In the-
not bound by me, Lordship.
Uh,
Degree is not bound against us, Lordship.
what was the decree for?
Degree, Lordship, passed by the Blaze Authority, Lordship.
Yes,
Degree was passed by the Blaze Authority, Lordship.
I'm sorry, madam. Matter may be passed over for timing, madam. Conducting council on the own.
okay.
Oblige.
Your lordship, may I?
Yes, 11. Yes,
Your lordship, in this application,
The eligible person and the complainant are jointly filed for quashing of Sangram Police Station case number 55/2009, along with the compounding the compoundable and non-compoundable offense and challenging the
Where is the,
FIR.
where is the complaint FIR, where is the?
What called, sir, this FIR, FIR is number.
It is joint application,
Pardon?
joint application.
Yes, Your Lordship.
Where is the FIR?
FIR page number 19 and 20, Your Lordship.
Page number,
19 and 20. Type copy.
what is page 18? That is the FIR.
That's the FIR.
Okay.
Not visible, Your Lordship. Your Lordship, in this FIR, the FIR name is not precisely mentioned. The
Who is the petitioner here?
here Dari Kanu and government doctors, Your Lordship.
What is the stage of investigation?
Investigation is completed.
Charge sheet file against whom?
No, the final report has submitted before learned with judicial magistrate.
Then what is the revision? Revision against what?
Actually, the learned judicial magistrate rejected the final report of IO.
Then
That's why I challenge the impugn order passed by the learned judicial magistrate.
rejected and now,
Now, learned judicial magistrate changed the sections 307 to 447, 451, 341, and 323. Read with section 3 PTP Act before considering of charge.
is there any stay?
Now going to CC, sir.
There is no stay. Where is the order, impugn order?
Impugn order, Your Lordship. Page number 22 and 23, Your Lordship,
Page 22.
and 23.
Only one accused.
Yes.
But there is no allegation against him.
Lordship, can
He was
he-
hospitalized, stitching was done, his relative attacked. What is his role? What is the material?
Doctor Lordship, he has Lordship complaint Lordship.
Uh-huh.
The doctor Lordship. the
Doctor
MO
lodged the
Lordship.
complaint saying that you were hospitalized. At that point of time,
someone admitted.
somebody had beaten you. So you were taken to hospital and he did some stitching on you. Okay.
Lordship.
Now some of your relative come and misbehaved him.
Yes, sir.
Okay, therefore he left the hospital with emotion and asked his nurse to stitch. Now what is the material against you? There is no allegation that you have done anything, your relative has done. If any case, offense is made out against your relative,
Lordship.
not against you.
Yes, sir, Lordship. And also,
And police has not sent
Investigate-
anybody for trial
Yes.
or final report. Final report also there is no name of anybody.
Yes.
there's more but in the charge sheet also Lordship. It is here, it is reported that prima facie is not being established due to the lack of evidence Lordship.
That's all.
Yes, Your Lordship.
Heard. Mr. You are Mr.
Neelam Talam. Neelam Talam.
Swenso, learned counsel for the petitioner. The present application is filed challenging the challenging the order dated 8/5/2024 and 12/6/2024, whereby formal charges were framed against the accused in connection with Sangram PS case number 55/2009, registered under section 307 IPC, read with section 3(1) within bracket 3 within bracket 1 within bracket 2 of PDPP Act 1984. It is on record that no, first of all, in the FIR is quoted herein below. Okay, page 19. From the FIR, it is seen that the present petitioner was brought to the Palin CHC, where the informant was a doctor and he treated the accused petitioner. It is also seen that the alleged attack and misbehavior the said informant doctor was manhandled by the relatives, allegedly by the relatives of the present petitioner and not by the present petitioner. Full stop. In the aforesaid backdrop, the investigating authority initiated investigation, and after completion of investigation, opined that there is no evidence to send the petitioner for no evidence to charge the petitioner under offenses under section 307 IPC or under section 3 within bracket 1 within bracket 2 of PDPP Act 1984. Full stop. However, by the impugned order, the learned magistrate refused to accept such final form and charged frame charges under section 447, 455, 451/341, 323, read with section 3 within bracket 1 within bracket 2 of the PDPP Act 1984. I have perused the material available on record, and it is seen that not only the informant, but none of the witnesses has implicated the present petitioner in commission of any of the offense as charged. Rather, from the material, it is seen that the allegation is primarily against unnamed relatives of the petitioner, and at the time of occurrence of the offense, the petitioner was himself in hospital, and there is no whisper against this petitioner. In the aforesaid backdrop, in the considered opinion of this court, the investigating officer has rightly filed final form by not sending the petitioner for trial. However, the learned full stop. Therefore, the decision impugned order of the magistrate framing charges, in view of the reasons recorded herein above, is not sustainable under law, inasmuch as there were no material available on record even to remotely suggest any offense that the commission of any offense that has been charged against the petitioner. In view of the aforesaid, the present application stands allowed by setting aside and quashing the impugned order dated 8/5/2024 and 12/6/2024 passed by the learned magistrate in connection with GR case in this venture. Petition stands allowed.
Madam.
Yes. Where is the affair?
My lord.
This is a bail application.
My lord,
Where is the affair?
this matter may be possible for a time being, because due to paucity of time, I couldn't peruse the TCR.
How many days he is inside?
More than 10 months, my lord.
No, now already charge sheet has been.
Charge sheeted long time back, my lord.
Okay, we'll take, you go through it, flag mark it, we'll take up tomorrow.
Yes.
Huh?
Oh, my lord, I have some
We'll
difficulty.
take tomorrow. We'll let us understand what
Very
is,
serious case,
huh?
very serious case. POCSO.
Whatsoever, you just mark the materials And any evidence started?
As on today, very unfortunately, even no charge has been framed, madam.
Do you have the case diary, scan copies of the case diary?
No, TCR was called for. TCR, trial court report.
No, trial court record, there will be nothing. In the trial court record, while he is present, so and so on and so forth. To consider a bail at this stage, we must see what are the materials against him.
Charge sheet must be there.
Charge sheet and case diary, that's why we always call the case diary.
Yes.
Because 161 statement is the foundation for proceeding with the trial. What is the implication against him? And see, already when charge sheet is filed, we are aware that this is not an indefeasible right to get bail. There are certain parameters.
Yes.
There are certain parameters to consider whether at this stage we will grant him bail or not. Even period of trial may not always be a consideration for grant of bail. In certain cases, we may say that, okay, first the victim be examined and thereafter we'll consider the bail. There are many aspects. So therefore, I want to see what are the materials.
164 section.
All these are there.
Yes.
164, 161 of the victim are there, medical reports are there.
Medical report. This.
You go
But I-
through it.
yes, I
We are
have to go.
fixing it tomorrow.
Yes.
You go through it.
Tomorrow, my lord, I have some difficulty.
So then Monday,
29.
29.
29.
Okay, just you see whether case diary is there. If not, I'll call the case diary today.
Case diary is not available. Case diary may be called for.
Charge sheet is otherwise.
No, charge sheet, there is nothing. No, they will just summarize it.
Since the matter, as my learned friend has said, is before the trial court. So if the TCR has come, it will be.
Have you been served with the copy CC?
Charge sheet has been, I have annexed in the.
No, not charge sheet. The 161 statements and the material that prosecutor.
Yes, madam. I have included part of my petition, charge sheet.
Okay.
I have included.
No, no.
164 I have included, 161 included.
You have included?
Yes.
Then it's fine. Okay. The learned additional public prosecutor submits that though he has received the record, however, he could not, due to paucity of time, he could not go through the same. Accordingly, he prays for a short adjournment. Prayer is allowed, list this matter on 29th. In the meantime, the learned additional public prosecutor shall go through the record so as to assist this court. Okay?
My lord, this, so far, my lord, inadvertently, medical report, I forgot to include my lord. Medical report may be called.
Well, that will be available in TCR.
That will be there. Okay, go through it. List this matter on, list this matter according, list accordingly. You are for the victim?
Yes, LSC form.
Office note dated 23/10/2024 reflects that service report in respect of respondent number 125 is not yet received. Await for service report and list of the forms. Just write a line in the first line, none appears for the partition. Then as per office. Yes.
I is for delay of following of 501 days in filing this regular first appeal.
501 days.
Lordship, this is an
Any
expert.
objection filed?
Yes, we have filed objection also. This is an ex parte judgment, which we because of that lordship, we couldn't come before this honorable court in that time.
Now, according to you, are not aware, notices were not served.
Lordship, from the record, it says that notice has been served, but without any who has served the notice, who has given.
Where is that?
Lordship, I'll take way straight way to the additional objection filed by my learned friend, Lordship.
Okay.
That is page 39, Lordship.
Page 39.
Of objection filed by the opposite party, page 39. The orders, Lordship.
Where is that affidavit?
They have not, Lordship, page 39 is the order, Lordship.
Page?
Page 39.
Page 39 says that refused to accept notice.
Yes, Lord.
Now, is there any order to serve by the independent person? There, see, it is a suit.
Yes.
When a suit is there is a procedure for issuance of notice.
Yes.
Service of notice.
Yes.
Process server, usual process, process server, and through registered post is AD. How you have taken steps?
As per direction of the Honorable Court, Your Lordship,
Whereby
the plaintiff was directed to take steps.
So what do you mean by takes? How is to be take steps to be taken?
Through the court only, Your Lordship.
Through the court. Have you taken?
Yes.
Where is the proof that it was served?
Lordship, kindly,
Page 35, Lordship. See, before we proceed any argument, let us understand the procedure.
yes.
A suit is filed, a notice is issued. And the court asks the petitioner to take steps. The notice is to be issued through the process server
Yes.
of the court
Yes.
and in a case through registered post and AD.
Yes.
In certain cases, court may allow to serve by dusty.
Yes.
Is that it? To take steps, there will be a report from the process server saying that I have served this notice upon this person. Service is complete. There may be.
Through process servers, but the steps was taken by the plaintiff.
Oh, what do you mean by steps? That's why I'm saying,
Steps.
understand. Steps means that you have taken the copy, all materials with writing this form and on and give it to the office of the court. Now the office of the court will send it through Jarikara, that is process server, and you will have to also give the postal stamps and all,
Yes.
and that will be sent by, or you will send it to the through the post, registered post,
Yes.
and all those postal receipt you will have to submit before the court. That means completion of service. Have you done that?
Lordship, the served and then accordingly the.
No, have you done that? Answer the question.
Because of.
You have not done that.
Lordship, this
What
is
you
the
have
order.
done is, I tell you, what have you done is, you have on your own went to serve him
No, not by own. Lordship.
by
The steps were taken through registered post.
registered post.
Yes,
Okay.
through registered post.
Now, where is that proof that this was delivered?
Kindly, kindly come to page 30,
Hmm.
35 onwards.
Huh?
35 onwards, page 35 of my objection.
Okay.
This is a part of record also, Lordship, of the, I don't know whether the record has come or not. Page 35.
Okay,
On
page
the top,
35.
Your Lordship,
Huh.
on 7/10/21, postman went
Hmm.
to serve. His mobile phone was found switched off.
Hmm.
Thereafter, he has waited till 25/9/2021. Again, he went to serve. Addressee got out of station
Hmm.
and they have waited for 7 days.
Hmm.
Then again on 8/10/2021,
Hmm.
the postman went to serve the notice.
Hmm.
Addressee was present.
Oh, where do you
Addressee
get it? Where addressee
refused-
refused to
returned to
return.
sender.
Refuse to return to sender. Then,
This is the remark, Your Lordship.
then,
Lordship, for that regarding, order 5, rule 17 says the law.
yes, tell us what's that.
Merit also, yeah. Lordship, merit. Order 5, rule 17, procedure when defendant refused to accept service or cannot be found. It says, whether defendant or his agent or such other person aforesaid refused to sign the acknowledgement, or where the servicing officer after using all dues and reasonable diligence cannot find the defendant who is absent from his residence at the time of the service is sought to be effected on him at his residence, and there is no likelihood of his being found at the residence with a reasonable time, and there is no agent empowered to accept service of the someone on his behalf, nor any other person or whom service can be made. The servicing officer shall affix a copy of the someone on the door, on the outdoor, or some other conspicuous part of the house in which
in which the defendant ordinarily resides or carries on his business or personally works for gain and shall then return the original to the court from which it was issued, with a report endorsed thereon annexed there those stating that he has so affixed the copy, the circumstances under which he did so, and the name and address of the person if by whom such was identified and whose present the copies was kept. Lordship, that the copy that is so far related, that's why I'm asking, that is so far relating to the process server. Yes. See, process server will have to come and file a report. Yes. Come and file a report saying that this postman is not a part of the system.
No, Worship, this is a private money suit case, Worship. In that case, and then when the
No, you are arguing something. Please understand, for my limited knowledge, my knowledge is very limited. From my limited knowledge, I understand is that first and foremost, the service to be effected through the office of the court by the process server. Now, process server will submit a report before this court saying that he refused. Okay, or I could not serve. He will give a report and return the service. What we are called service, this is a return of service report.
Yes.
When service is issued, a date is fixed for SR and WS.
Yes.
Means service report and written statement.
Yes.
Now the process servers will come and say that service is, why have you filed an application for vacation of expertise? I have not filed a lawsuit there since I came to know about this when there was an execution petition against me. So there. Now what is this application? Lawsuit, this is for causing of that impugn expertise as well as the judgment and decree. Under what provision? Lordship, that is under, that is come under section 96, read with order 41 of CPC. I have a, either I can go there under order 13 for recalling of that. So you have filed, this is a first appeal? Yes, first appeal. This is a first appeal? Yes. So when is that the judgment was passed? Judgment was passed on 5/2 of 2000. So you are arguing on merit only. You are not seeking, you cannot challenge that order until and unless you seek a vacation of the decree, expertise decree.
Here the applicant ought to have approached.
No,
before
ought
the-
to have, he have two options. Either he can file an application for vacating the expertise decree and for a fresh trial. Then court will see whether notice was duly served. If notice was duly not served, then court can recall it. And other option is to challenge the decree. Okay, now he has challenged the decree. For that there is a delay. He explained that this was an expertise. So we'll condone the delay, that's all.
Apart from that,
Huh?
this another condition is also there. He was sick, medical. And then also, he has.
What is that? What is the execution proceeding? Lordship, the execution proceeding, like I have been, a civil warrant was issued against me. I was arrested, and like I was released again, and they have. What is the amount? The amount is 58 lakhs 25,000 against loan. Against the personal loan. That was, I had not taken that loan. I had taken in the defendant number 2. There was defendant number, there were 3 defendants in the trial court also. Okay, we are not going to merit of this case. Because you have filed a decision first appeal, not a application for vacating expertise.
The delay is, Lordship, more than 500 days. Now, he has filed an application, Your Honor, on 6/9/2022. Under section 148 and 155 of CPC, wherein that also have enclosed that application.
Filed before whom?
Before the civil judge senior division.
What is that, what is the application?
That is in, sir, execution lordship, I filed
In the
the
execution,
not,
last paragraph, he stated that your humble applicant submit that he is ready to pay the said critical amount whenever he manage the same, and the applicant furthermore submit that being a government employee under the Government of India undertaking, as such there is no likelihood of jumping. He has admitted, your lordship, in the application also he has given undertaking before the honorable.
That cannot be a binding to give a decree that
And,
this is an admission.
And another ground they have taken, he has came to know on, even if, let us presume, that the, as per this application.
Two aspects. Suppose in this, his whole ground of condonation of delay, that it was an ex parte degree. Okay? Some health issues. Forget about the health issues for the time. Now, ex parte degree, admittedly, it is an ex parte degree. Now, whether he was negligent, did not appear and all, of course, can be a subject matter of vacating the ex parte degree, which he has not obtained. Now he's come for appeal. We'll hear this appeal on merit.
And
will because he has given up all his right to file written statement. So his invariably his suit his this appeals is will going to be dismissed because he did not have any defense. And we'll see only whether you have pleaded and your pleadings are supported by evidence. That's all. Because he has not come for ex parte vacating, he has waived his right. He has waived his right. He is not saying that please give me, allow me to participate. This was genuine, this or that. That is, that part is gone by filing application. We will not go to that because he has not opted. Now what remains is whether the decree is correct and rightly passed on the basis of pleading and evidence. Because he did not cross-examine, he did not file his defense, because he don't have any defense. So only we'll see the limited thing of whether you have specific pleading and you have proved your case. That's all. And that is going to be he's done a futile exercise here.
And
isn't it? Can we decide your claim in this appeal that I am not this, I am not that? Can we?
lordship, our basic contention is whether that ex parte order was passed as part procedure of law or not, lordship. If that goes, then everything goes, lordship. Like in my prayer also,
we will not go to that. One aspect will not go. Yes. Whether it was served, not served, because therefore that there is an option to go for ex parte vacating. You have not gone for that.
there is a
You have
report-
challenged the main appeal. We'll go on merit of the appeal.
there is a report from the postal department, your lordship. In regard to that, your lordship, there is a judgment, your lordship.
Oh,
lordship.
judgment.
There is
Appeal is on judgment.
Because in that judgment, it specifically says that, your lordship, service by postal, presumption of refusal by addressee to accept service, the notice served by the registered post are deemed to have been served.
Did you examine the postman in the court before proceeding ex parte?
nothing, lordship.
This court order itself says, your lordship.
What court
Deemed
order
to be
says? How
served.
can court believe straight away that a postal person is, even in certain cases, Jari Karaks are examined. Don't say judgment on this.
All right, Lord. Thereafter, after filing
See,
the application, your lordship.
if we accept this kind of things, that some postman has said that he has refused, matter ends there, will damage the whole system. The postman is not part of the administration of the judicial officer. He will have to be examined. Yes, I went there and so and so. Where is there an examination? Even Jari Karaks are examined. We will have to give is it on oath? Is it on
Lordship,
oath?
that affidavit was filed, your lordship, before.
By whom?
By the plaintiff.
How do you know that he was there?
Affidavit was also.
What
filed.
is the meaning of affidavit? Is it true to my knowledge? Did you witness that this person has went there and refused? That's why I'm asking, was there any dusty? Then we would have examined.
Dusty
Dusty
was
has been given.
Dusty
I went there. He refused. Okay, we'll accept that. because that is an oath.
Even
Why we pass an order saying in Dusty Service that please file an affidavit? Why? What is the meaning of that? Because we cannot believe that service is completed. That's why an affidavit is required by the person that yes, I went, I served it in before so and so, so witness. There is nothing in this post, peons. He has in regular course of his duty has written it.
as per General's Clause Act, Section 27 also, it says that when the addressee refused to.
Problem is
Yes,
this,
that is.
all
And
these
then-
laws are settled. Service, deemed service, through registered service, all are vulnerable. Therefore, court in case of ex parte decree on the basis of some kind of services always says no, this cannot be treated to be a complete service. But unfortunately, he has not opted that and will not deal with that. He has not opted that.
Subsequently, Your Honor, when he has applied, when he has filed application, and given undertaking that he will pay the entire decreed amount. On that was on 6/9/22. And thereafter also, 5 months has also been elapsed. Then also in between that, he has not filed any application.
It is not subject matter, our subject.
So the explanation
Well,
in that petition, Your Lordship, is not convincing.
no, that is a
And
subject
then,
matter of executing court. We are not here executing court. We are here to decide whether we will condone the
I'm
delay or
not
not.
trying to decide, just I'm trying to, Lordship, show that he has knowledge. Even
We
that
are
he has
giving you a
knowledge,
chance to think over.
he has knowledge to,
You proceed, there is no step, proceed with the execution, we have nothing to be done. We are adjourning this method.
your entire execution proceeding is also probably, I think, over. Final order has already been passed.
Over,
Pasted over the property also.
money is recovered.
That's the part-
Proceed with that.
Nothing is.
At the end of the day, this appeal is going to be dismissed. Lordship, in that, this appeal is going to be dismissed for want of any evidence, any pleadings on your part. We cannot hear you on merit of your defense because you did not have any defense.
Yes, Lord.
That part is gone. Only thing we will decide is whether the pleadings are there and in support of these pleadings, evidences were there because there is no cross-examination. So if without cross-examination, that evidence is absolute. So decree is rightly passed, we will not go ex parte, dis parte, we will not go there. Because you have not opted for vacation of the ex parte decree.
In our prayer, Lordship, we have made the.
No, why should we decide? It's the first appeal. On the prayer of the learned counsel for the parties, list this matter after 2 weeks. Think over it, still you have time.
Leave it alone.
But we may not condemn the delay also. Looking at your conduct. But only problem is that the ex parte was initiated on the basis of a report of a postman. That is not accepted.
Thereafter also,
no,
thereafter also,
if
let
you-
us presume, Lordship, that was. Thereafter also, his conduct was absolutely, he has
That
appeared, Your
conduct,
Lordship.
that conduct is not subject matter. What we want to see is, was there any steps for some issuance of notice to the process server?
That
Look
part
into
also
it.
we will
Go
try
through-
to,
go through
try
it.
to obtain that.
You have that. If there is a process server service, report was there, then we'll say that delay will not condone.
For sure, I will try to obtain.
But not on the basis of this postman's. This is not accepted.
After a week, Lordship,
When?
after a week, Lordship, any date, my.
Next week, Lordship, I have some difficulty.
After 2 weeks. Because we cannot allow a litigant who will not accept notice and after 2 years, after a decree is obtained, will come and say that this was ex parte, I did not receive notice. We will meticulously see whether service was complete, except not by on the registered post. Law is well settled. It has said that this registered post, deemed service, these are always doubtful. That cannot take away right of defense. Of course, if it is Jari Kara, served, refuse, fine. That's all. If report is there, court has on the satisfaction of that accepted, matter ends there. That is what you want to say. That is the principle of law.
I try to obtain
Yes.
certified copy and I'll
If that is there, that's fine. I think there will be some report by the Jari Kara because it's a process of the court. You also find it.
Usually, Lordship, here in our practice, we don't use process server. What we do is here, once the court.
Oh, we do, your practice will.
That's what Lordship,
is not relevant in terms of the CPC. If you say no, CPC is amended, here is, that is.
No, Lordship, what I'm.
Practice, we are not on practice. Practice thing many way, because this is the high time you people learn. Because you have adopted CPC. We will be strict. Initially, we were a little bit reluctant. Now we'll be strict. Yes, next question. Yes, tell us, Theory, what is this?
Yes, my lord. Since this is a revision petition, my lord, I will be strictly to my lord jurisdiction partner.
Yes, tell us.
There was a land dispute, my lord.
There
Boundary dispute, my lord.
boundary dispute.
Yes, my lord. Now, I had purchased one land, my lord. Meeki land, my lord.
Before that, let us see the impugn order.
Impugn order, yes, my lord. Page 39, my lord.
Yes, 39.
Yes, my lord.
This order is passed by the Deputy
Deputy
Commissioner, West Siang District.
Yes, my lord.
On whose application?
My lord, he himself has filed this, passed this order.
No,
His
no.
application.
Huh?
Oh, I have filed an appeal, yes.
Okay.
I have filed an appeal. Yes, may I read?
You are Pinken Dozy.
Yes, my lord, Pink and Doji.
So there was a KEBA decision on 23/2017
Yes, my lord.
passed by Village Authority of Dozy Jeko Village.
Yes, my lord.
Now, by that order went against you.
Yes, my lord.
Then you preferred an appeal
For the deputy commissioner.
for the Deputy Commissioner. Under what provision?
My lord,
Where is your appeal petition?
appeal petition would be, my lord, at
72.
72, yes.
Page 72.
On the section 46 of 1948, regulation 1945.
Page 72. Okay.
Yes, my lord. Now, my lord, may kindly appreciate the impugn order, my lord. Page 39.
Page
39. Yes, this one. May I read, my lord? From second paragraph, my lord. On perusal of the record, it is alleged by the appellant that regarding his ME WRC field, the impugn KEBA has been conducted in between Sri Redo Doji and Sri Jundak Doji and others. The KEBA authority of Doji Jacob Village has decided the dispute in favor of Jundak Doji and others. Against the said KEBA decision, the appellant Sri Pinken Doji has filed this appeal. Whereas in the impugn KEBA decision, the appellant is not made as necessary party, but his land is involved and accordingly he is affected. Therefore, this court is of the view that since the appellant is not a necessary party in the KEBA decision, his appeal petition cannot be maintained without involving the other party in the impugn KEBA decision, namely Redo Doji. As such, this court, under provision of CPC, in spirit hereby orders to return the appeal petition to the appellant at his liberty to prefer appropriate suit before the competent court.
Okay, let us see the KEBA decision.
Page 43.
Page
43.
Your name is
Pinken Doji.
Pinken Doji. KEBA decision is at
KEBA decision is at page 43, my lord.
43. It was
Yes,
initiated.
translated copy is page 46, my lord.
Now initiated.
No, my lord, I will stick to page 39, my lord, impugn KEBA decision.
Now tell us, Pinken, their dispute was between Pinken Doji and Redo Doji.
My lord, what happened? I have purchased a land from Redo Doji. Now, this respondent number one, my lord, has initiated Kaba proceeding against the Redo Doji, my lord. Actually, that land does not belong to Redo Doji. It belongs to me because I have purchased that land.
No, no, understand.
Yes, my lord.
You are Pink and Doji.
Pink and Doji.
And dispute was between Pinken and Redo Doji.
Yes, my lord. My lord, this respondent number one, my lord. Respondent number one is
Kaba decision at 46 says
yes, my lord.
that village meeting sale and purchase of between Pinken Doji and Redo Doji.
Impugn Kaba decision is page 65.
Oh, no, no, my lord. Yes, yes.
What is page 46?
Oh, that would
That's
be
the earlier
first Kaba decision.
Oh, whatever.
Yes, yes. Sorry,
Page
ma'am.
65. Translated copy
65. Yes, ma'am. Sorry, ma'am.
translate copy
68.
68.
Yes, ma'am.
Hoge Doji and Jamduk Doji.
Yes, ma'am. To the effect that Redo Doji, ma'am. Redo Doji has no land, madam. The land has been sold.
Let us,
Yes.
we'll go to the facts later on. Let us understand who has
Yes, yes.
complained what.
Yes, ma'am.
Now, Hoge Doji and Jumdak Doji
Yes, ma'am.
has filed a complaint saying that one Redo Doji is encroaching the land by erecting fencing.
Yes, ma'am.
So their grievances against
Redo.
Redo Doji.
Yes, ma'am.
Keba visited the spot and what is the final order?
This is the final order.
No.
For demarcation.
Demarcation. Yes, ma'am.
Decided to demarcate the boundary.
Yes.
So between Hoge, Jumdak
Redo.
and Redo. So there is to be disputed. Now, according to you,
Yes, ma'am.
this decision affects you.
Yes,
Isn't
my
it?
lord. Yes, ma'am.
By whatsoever reason,
Yes,
this
ma'am.
decision affects you.
My lord may
And
come to down
according-
below case owner.
Listen, let me
Yes, ma'am.
understand.
Sorry, sorry.
Let me understand first.
Yes, ma'am.
Because there is some fundamental and points.
Yes, ma'am.
If you can understand that, it will take you 5 minutes to decide.
Yes, ma'am.
Let us not go whose land, how much land. This is not issue here.
Sure thing.
Our issue is that your whole case is this.
Yes, ma'am.
That a Keba decision is passed
My lord.
in my absence.
In my presence.
Huh?
In my presence. I'm also a party. My lord, case owner, my lord. Pink and Doji, my lord. I was there, my lord.
No, no. In 68, are you a party?
I was the party, my lord. I have participated, my lord.
You have participated.
Yes, my lord.
Okay, okay. You also participated, though dispute was projected to be between Hoge Doji and Jumdak Doji
Yes, my lord.
and Redo Doji.
Yes, ma'am.
In fact, you are the main person
Yes, my lord.
in this proceeding.
Yes, my lord.
So the order affects you.
Yes, ma'am.
This is your case.
Yes, ma'am.
Therefore, you have a right to prefer an appeal before the Deputy Commissioner.
Yes, ma'am.
Accordingly, you have preferred a appeal before the Deputy Commissioner.
Yes, ma'am.
However, Deputy Commissioner says that others are not party in the
Redo Doji has not been made as party.
not party. So he says, I am returning this thing and do the needful to file a suit.
Yes, ma'am.
Why did you not made all these others as a party in the appeal?
Now, my lord. Now, my lord, that's why, my lord, I am on page 39, my lord. Impugn decision, my lord. My lord, may I kindly appreciate page 39. Return of plate, my lord. CPC, how, my lord, it, my lord, makes procedure for return of plate, my lord. When you say, my lord, return of plate, my lord. Return of plate, my lord, the court does not have jurisdiction. You approach appropriate forum. Why? Because at that point of time, Civil Court Act was come into play, my lord. Came into force. My lord, Civil Court Act came into force on 12 April 2021, my lord. And this order was passed on 36/2021, my lord. So 2 months, my lord, is there, my lord. Because of enforce of this Civil Court Act, my lord, my suit, my appeal was returned, my lord. Now, when I say, my lord, the return of appeal petition, so it is guided by, my lord, CPC, my lord, may I?
No, just we'll go to that return part later on.
Yes.
Please tell us, suppose we say that your appeal is maintainable,
Yes, my lord.
but this appeal, everybody should be a party.
Yes, my lord. But when, my lord, when the learned court below says that, return the plane, my lord.
No, no, return will come later. Don't say, let us not go to the return first. Where is your appeal memo before the deputy commissioner?
Appeal memo is page 60,
72.
72, yes, my lord.
Page 73, my lord.
Where is the, just let us see first this Keba decision. Again, which page?
My lord,
65.
Keba is 65. Give me 5 minutes to understand, huh?
one thing I will, my lord,
Page 68.
assist, my lord. After this order, my lord, deputy commissioner order, I have approached the district and session judge, district court, my lord, page 86, where the Redo Doji was also made as a party, my lord. But on the principle of res judicata, my appeal was dismissed, my lord. Because of that, against the deputy commissioner order, I am here.
And that order is not under challenge.
No, that would be filed. I will file a review petition, my lord. I'm in revision petition, my lord. I am challenging the order of the deputy commissioner, my lord.
68 is the type code. Memo
So
within
after this
72.
deputy commissioner's order, you have approached whom?
District judge, my lord. District
Under,
court, district court.
under what provision?
Under the civil court act, my lord.
15-3.
15.3.
Yes, my lord.
Now what it says?
It's a, my lord, it's an appeal from the, my lord, all the pending cases would be tried by the deputy commissioner, my lord, district judge. Within a period of 1 year, which has not been disposed of by the deputy commissioner. my lord. I have prepared appeal, my lord. On the principle, because there has been some observation, cannot maintain the, my lord, this appeal petition.
Where is that order?
Page 86. my lord.
That is also under challenge.
No, my lord. Because that would, I will file a review petition. My lord, I am on revision, my lord. I am against the order of the deputy.
No. You see, you have opted against, see, an order is passed by the deputy commissioner,
Yes, my lord.
which may be wrong.
Yes, my lord.
Against that order, you have preferred and remedy
Yes, my lord.
before the district.
No,
and session.
not against that deputy commissioner order, my lord. Because deputy commissioner has returned my appeal petition, my lord. So I have approached appropriate forum as per the civil court act. But the district judge says, my lord, this has been decided by the deputy commissioner. So the principle of res judicata is applied here, my lord.
Where is that order?
Page 86, my lord.
According to you, you should be allowed to continue with the civil appeal number 3 of 2021.
Yes, my lord.
This is your case.
Yes, my lord.
Now let us see the provision.
Provision, my lord.
This was filed against what?
Against the Kaba decision, my lord.
Keba decision?
Yes, my lord.
Under what provision?
On the section, I have not, my lord, filed a petition, appeal petition, but the order is here, my lord.
Where is the provision? Tell us.
Yes, my lord.
And give the book.
Civil court act.
There was a
15.
grace period of 1 year.
Okay.
All the pending cases before the deputy commissioner was to be decided by the deputy commissioner with a period of
Now,
1 year.
where is the first, let me see, where is the provision prescribing an appeal before the district and session judge against Keba decision?
15, my lord, at page 3.
15, appeals.
Yes.
Appeals from the decree and orders
Proviso.
passed by the court.
Next page. Proviso, my lord. It is in the proviso, my lord. First proviso, my lord. Provided that
Where is that?
page 15.3, after 15.3, my lord, proviso, provided that any appeal,
15.3, class of civil code.
my lord, just provided, proviso, my lord.
Where is that proviso?
At page 4, my lord. Just
Page,
after-
page 4.
Yes, sir.
No, this is page 2. There is some mistake in pagination. Okay,
Oh,
page 4. 3, appeal go. Provided any appeal on civil suits pending in the court of deputy commissioner shall be disposed of by the concerned deputy commissioner under provision of as actually possible, but not later than 1 year from the date of coming into force the act. Provided further that from the date of commission act, in case of an appeal is preferred against the judgment of customary court in the court of district judge or in the additional judge as the case may
That
be.
is all.
The court of district judge, session judge may dispose of the same, proceed with case with the de novo. So, as expeditiously provisional, but not later than 1 year from the coming into force of this act.
Yes, sir.
Now, please tell us when have you filed this appeal?
This
Date
appeal
of the appeal against KEBA decision?
against cover decision, yes. Sir. Against cover decision before the district judge, my lord.
Not the district judge, before the deputy commissioner.
Deputy commissioner, my lord.
Sometime in
21/6/2017.
21/6/17, you have filed before the DC.
Yes, ma'am.
Is not it?
Yes, ma'am.
Now, when it was decided,
It was decided on, my lord, that annexure 1, so, my lord,
tell us the date.
36/2021.
36/2021.
Yes.
When this act came into effect?
12 April 2021.
12/4/2021.
Yes, ma'am.
So he has decided within the 1 year.
Yes, ma'am.
If he has decided under 1 year, now what will be the remedy against that order?
Now, what I am saying, my lord.
No, please tell us.
Yes, ma'am.
What will be the remedy in terms of the act? Forget about your case.
In that case, my lord,
See,
before the High Court.
in earlier, the frontier so and so.
Yes.
What was the remedy against order of appellate order of a deputy commissioner?
My lord,
It was
revision.
Revision High Court.
Yes, ma'am.
Revision High Court.
Yes, ma'am.
Now, any provision under this act prescribing what will happen to that revisional power?
Nothing.
Nothing means no exclusion of that power.
Well, my lord, yes, my lord, revision has been done away, my lord.
No, revision has been done away from which date?
From this 12 April, my lord.
Please tell us.
Section, my lord, AP code, I do not have, my lord.
See, now what we understand is, since it's a jurisdictional issue,
Yes, my lord.
subject to what you say, because I'm not so accustomed with this law.
Yes, ma'am.
power was conferred under Regulation 50 for
Huh.
revision before the High Court. That
Huh.
was deleted.
That was deleted.
Yes, ma'am.
Now, situation is this. A person cannot be remediless.
Yes.
Okay. A person cannot be remediless. Here is a case. The frontier regulation prescribes an appellate provision against the decision of the KEBA
Yes.
or customary court
Yes.
before the deputy commissioner.
Yes, ma'am.
Okay.
Yes, ma'am.
And an aggrieved person is having a remedy under the frontier regulation to prefer a revision.
My lord.
This was the
Yes.
law.
Yes, ma'am.
When this application was filed,
Which application?
that his appeal was filed. We'll come to the merit later on. When appeal was filed on 21/6/2017, the statutory appellate authority was the deputy commissioner.
Yes.
No doubt about that. And the deputy commissioner had a right to decide an appeal till 12/4/2022.
Yes.
Okay.
Yes, ma'am.
So he has decided the matter on 36/2021. So it cannot be said that he did not have
Yes, yes.
jurisdiction to
Absolutely.
decide. So he has decided it. Now on he decided on 36/2021. On that day, already this act came into effect, new act,
Yes, ma'am.
on 12/4/2021. Now the new act deletes the provision of revision.
Yes, ma'am.
Okay.
Yes, ma'am.
So what should be the remedy on 13/6/2021 against the order of the deputy commissioner?
My lord, since there is no remedy, so what Article 227?
So Article 227.
Yes, my lord.
But you opted for the district and session judge.
No, my lord. That's why, my lord, there is an observation, my lord. Since, my lord, return of plaint, my lord. Return of plaint, that is why, my lord, that is my case, my lord. May I read, section, my lord, CPC, my lord.
Where the CPC comes?
Because, my lord,
We accept that deputy commissioner's order is wrong.
yes, my lord.
Can that be declared to be wrong by a district and session judge under the scheme of the act? Tell us.
My lord,
Your case is that how can this concept of return of the plaint.
Yes, my lord.
Where is his authority to do that? We accept this proposition.
My lord, he has returned the plaint,
Huh.
returned my appeal, but he has made an observation, my lord, deciding my rights, my lord, deciding the core issue, my lord, maintainability, my lord. Now, that would be, my lord, beyond his jurisdiction, my lord.
That is what we are saying.
Yes, my lord.
Suppose we accept your argument as on date,
My lord.
but can that be decided by a district and session judge?
So I was on the wrong forum, my lord, in that case, my lord.
Wrong forum, we understand,
My
but
lord.
already a judicial order is there.
My lord.
Is it not necessary to say, deal with that order? Because it is intrinsically connected.
Yes, my lord.
File an amendment, challenge this order here.
Because if your lordship allows this petition also, the prayer made, the Kabang order stands and the order of the district judge stands.
So, my lord, what I am saying, my lord, I may be given a remedy, my lord. I am remediless.
I am saying you cannot be remediless. Your remedy will be Article 227 will always remain there.
Yes, my lord.
227, this is an application under 227.
227, yes, my lord.
This will remain.
Yes,
That is not an issue.
Yes, my lord.
No person can be remediless. This is not an issue. But issue is, while passing an order, we'll have to deal with the order of district and session judge. Because this problem has been invited by you.
My lord, if there is a order from this honorable
Listen,
court, I can file a review petition before the.
No, we do not know. What you can file, we do not know. But today, if I am going to decide this,
My lord.
I will have to address these issues.
In that case,
Will there be anything remains to file a review if we enter into?
Because
And can we entertain and decide a order, more particularly in an application under 227, touching the correctness, jurisdiction of district and session judge or your action approaching that? We can even accept that in 226, it's an extraordinary power, we may do it, even without challenge. But 227's power is, in that sense, is really limited.
Because the second prayer is that the appeal be decided. But now in terms of the act, the deputy commissioner is barred. Now the district judge order stands, that is not under challenge.
That is under challenge.
My lord, what time?
Mr. Don't argue cases where you have a scope of rectifying.
My lord. In that case, I may be allowed to amend my civil revision.
We do not know what will you do.
By that
You
way,
can
my lord, I
amend
will
it, you can withdraw it, take all these grounds. At the end of the day, your grievance is to be decided by a competent authority.
My lord.
Maybe deputy commissioner, maybe some civil suit, whatsoever. We are not commenting on as on date. But he is right that in this situation, we will have a limited scope. We will have to say that since already that has been decided, that is not under Sandel, it will not be appropriate for this scope to deliberate and comment on the order of the district and session judge, more particularly in an application under 227. So if that be so, when you have already opted a remedy and answer is given, in absence of challenge to that, how can we again go back to that which will ultimately amount to interference with the decision of the district and session judge?
My lord, in that case, my lord, I may be given some time, I will file my amended petition, amended application. Why? Because, my lord, I was.
No, I understand. You cannot be remediless. Of course. Yes, fine. Let him have a
That's why in the morning itself, I said the whole thing. I would have prayed for allowing their prayer actually. It does not affect me.
You did not affect. That remains. Mr. Deori, learned counsel for the petitioner, submits that there are certain defects in this petition, in as much as an order dated. District and session judge.
District and session judge order dated, my lord, 21/12/2021. 21/12/2021.
21/12/2021.
In civil appeal number 03/2021.
In civil, passed in civil.
Appeal number.
Civil appeal number.
03/2021.
03/2021, which is intrinsically connected with the issue in question, is not under challenge in the present petition. Therefore, he may be granted some time to either file amend this petition or to withdraw the present petition with a liberty to file a fresh application. On accordingly, prayer for adjournment stands allowance.
My lord may say that to take necessary steps because there will be question of limitation also in that.
227, there is no limitation.
Anyway, we are just saying that it's up to you.
Yes.
You have given many advices,
Yes, yes.
not beyond that. Our job is to do pass judgment, not to advise.
My case is that, my lord, while my lord returning the plaint, he says he does not have any jurisdiction. When he says he does not have any jurisdiction, he cannot pass any order.
Well, that will be different issue.
Yes, my lord.
But that issue you have agitated, this is the same ground.
My lord, my
You
lord.
have agitated before district and session judge, which has dealt it
Yes, my lord.
and dismissed your petition.
My lord.
Isn't that it?
No,
At the end of the day, what you are arguing,
My lord.
you have argued before the district and session judge.
Yes, my lord.
That has been negated. Why should we entertain this petition?
That was negated on rest.
Whatsoever.
Yes, my lord.
We can right now dismiss it in 2 lines.
My lord. Always, my lord.
Huh? No. Prayer stands allowed. Accordingly, list this matter after 2 weeks. In the meantime, the petitioner may do the needful in this regard. Yes.
Yes, Lordship. Lordship, here the petitioner is challenging the order of the additional deputy commissioner, Lordship, whereby after passing an execution order, here again state the execution order and kept it for end.
Where is the impugned order?
That is page number 19, Lordship.
Uh-huh.
Page number 19, Annex 1. Based on an appeal filed by the respondent, Lordship, the execution order that was passed on 29/2/2024, Lordship, that has been kept in abeyance by the additional deputy commissioner.
What is wrong? They all want to hear it once again.
Yes, Lordship. Lordship, I may be given an opportunity, Lordship. In this case, Lordship. Here, Lordship, execution petition, Lordship. In executions, order where.
So,
Yes.
admittedly, what we could understand is that there is an execution procedure.
Yes, Lordship.
Now, somebody, while executing, somebody comes and says that I have also right, I may be heard.
Yes, Lordship.
Deputy Commissioner said that we have stayed it, we'll hear it. Better ends there.
Yes, Lordship. I may be given opportunity, Lordship.
Huh?
Yes, Lordship.
Yes.
Opportunity may be given, Lordship.
Huh? Okay, fine.
Yes.
Lordship.
We'll dispose it of.
Yes.
Okay. We'll dispose it of.
Executing courts, Lordship, have a power, Lordship.
Nothing, no,
Decide the issue, Lordship.
no decision has been taken. We'll observe that he can proceed with the hearing and pass an order as per law.
Yes, Lordship.
That's all.
Yes, Lordship.
You will also be heard, he will also be.
Yes, Lordship.
Okay.
That's all, Lordship.
Yes. How many matters? Huh? Come back. Huh? Disposal. We'll pass it as dictated, or I may dictate after coming. I'll have a glass of water. We'll come and go. Give me 5 minutes, I'll come back. Too many dictations, need a cup of tea. Yes.
Lordship, I am for appellant here, Lordship. So, Lordship, paperwork has been received, Lordship. So, matter may be fixed for admission hearing.
Hearing?
Yes, Lordship.
On this
Okay.
informant part of service not complete, but I think it's not that necessary, Lordship.
Who is,
Informant.
offense is under?
Offense 304.
Huh?
304.
Part 2, Lordship. 304 part
5
2.
years conviction.
The paper book has already been prepared by the registry and the learned councils has also received the same. full stop. Though, service is not complete upon the respondent number two. However, in the considered opinion of this court, the respondent number two is not a necessary party as the offenses are under section 304 IPC. Full stop. However, it is made clear that the petitioner, the respondent number two, shall be at liberty to participate in the proceeding as and when wishes. Full stop.
Service may be
Accordingly-
completed, Lordship. Service may be completed.
Accordingly, let this matter be listed for hearing. When?
After 2 weeks, Lordship.
After 2 weeks.
Much obliged.
Yeah, Lordship.
Yes.
Lordship, I, on behalf of Lordship, I mean, also have some personal difficulty. Also, this matter may be listed after a week, Lordship.
This is a criminal appeal,
Yes,
criminal petition.
yes, Lordship.
The matter is as ready as regard service and record accordingly. List this matter in the admission column. When?
After a week, Lordship.
After weeks.
Much obliged.
None appears for the parties on call. However, in the interest of justice, matter stays adjourned and be listed after 3 weeks.
Your Lordship, I apologize, Your Lordship. In item number 18, my appearance may be recorded in 18.
Mr. Swenso,
Deeply obliged.
yes. Now item number,
21.
yes, what is this?
My Lordship, may I?
In view of the office note dated 23/10/2024, await service report in respect of the sole respondent, full stop, registry to issue reminder for the LCR. Full stop, list this matter after.
No, sir. Lordship, it's a, I have an instruction from the petitioner to withdraw this case.
Okay, the learned counsel for the petitioner submits that she has instruction. Learned counsel, MS Swenso, learned counsel for the petitioner submits that she has instruction from her client to withdraw this petition. Accordingly, the present petition stands dismissed on withdrawal.
Much obliged.
My lord, service report is awaited in.
I have been instructed to.
Appear for respondent number, sole respondent. Okay, though office note dated 23/10/2024 reflects that service report in respect of the sole respondent has not yet been received. However, Mr. Learned counsel submits that he has instruction to appear for the said respondent. In view of the aforesaid, service is complete in this matter. Accordingly, list this matter in the admission column
After 4 weeks.
after 4 weeks.
Lordship.
That you want to.
Yes, your Lordship, release.
And whatever the, will come to your petition, your IA, just wait for a minute. Now, yes, Mr. Majumdar.
Yes, my lord. My lord, I am appearing for the respondent return candidate. And we have filed an application under Order 7, Rule 11 for rejection of the election petition.
Have you filed any objection to that?
Yes, fine.
Huh? We have filed it? Okay, it is on record, no? Okay, before that, we'll come to that. Just wait for a minute. We are going for hearing?
Yeah. Yes.
Okay, just wait for a minute. Let us see this IA, District Election Officer. What do you want?
Your Lordship, I'm praying for releasing of EVM, your Lordship.
Mr. Majumdar, There
My
is no, there is no need to keep the EVMs in this case in the backdrop of the
No, my lord.
allegation. Not
No,
necessary.
not
Because
necessary.
it is something different, so we'll allow this.
Different. My lord.
Even the election petitioner doesn't have any objection here.
Okay. Just write it down. IA 140 is not it?
140, yeah.
140. And what is IA 188? This is your petition by that. The present application is filed by who filed this?
District election officer.
Filed by the
District
district election officer. District election officer. Of which district?
Changlang TS.
Changlang district.
Of
Changlang.
Changlang district.
53 Changlang.
With a prayer to release the electronic voting machine within bracket EVMs / VVPATS for further use, which are kept in strong room under custody of district election officer Changlang, as the said as the election to the Changlang 53 Changlang North ST Assembly constituency is challenged in the connected election petition number so and so. Full stop. The parties have submitted that the EVMs will have no relevance, nor that can be used as an evidence in the election proceeding, and therefore the contesting parties has no objection if the present petition is allowed. In view of the aforesaid, the present IA is allowed, full stop. The district election commission shall be
District election officer.
district election officer shall be at liberty to take out the EVM / VVPH of 53 Changlang North ST Assembly constituency for further use as and when required. Accordingly, IA stands.
Obliged.
Mr. Majumdar, how
My
many
lord.
members are there? Just wait for some time. We have some 3 matters. We'll conclude and come back to you because it will
Well-
take some time.
Yes, yes.
Just wait for some time. This IA is pulled up. Which IA 140 AP 2024. This matter will take after finishing the list.
Second number 24.
24.
In this matter, Lordship, we have lost track of all the petitioners, Lordship. It's anyway, Lordship, after all, some order has to be passed.
What
And
is the issue here against which order?
issue, Lordship, is order passed by the additional Deputy Commissioner Changlang.
Any
But-
urgency in this matter today to be decided?
No, no.
Then since this election matter is there, we are not taking up today. Okay.
Lordship, if my colleagues, if they agree, the matter may be remand back to the concerned authority for further hearing or whatever it is, Lordship.
Do you have any instruction? Huh?
Next step, on next step, we'll pass this.
On next day, you have
Yes.
instruction when we'll pass, when we'll fix this matter?
Sir, after 1 week.
After Monday? After
1
2 weeks? 1 week, 2 weeks? Or next week?
So 1 week. After 1 week.
Okay. I was agreed to by the learned council for the parties. List this matter after a week.
Obliged.
Yes, Mr. Dekka.
May I please, your lordship, this is,
Hearing.
I am ready for hearing, but opposite party is absent.
Today, see, this election petition will
Yes,
take some time.
My lord. Okay,
That's why we went for a cup of tea.
My lord, opposite party is not available here. So
Though Mr. Decca learned, Decca learned counsel for the appellant is present. However, none appears for the
Yes.
claimant respondent.
Yes.
Full stop. In the interest of justice, matter stands adjourned and will state
after a week.
after a week. Need glass of water. Little warm.
Where?
Yes.
Lordship, this is joint petition, Lordship.
Joint petition.
Yes, sir. For quashing
Where is the FIR?
FIR, Lordship. FIR is page number 21, Lordship.
Page number
21, Lordship. And complaint letter, Lordship. Complaint, Lordship.
Page 19.
Yes.
To officer in charge police
Yes.
station Alo.
Yes, Lordship. Lordship, type copy, Lordship. Page 19, Lordship.
Page 19, huh?
Yes, Lordship, type copy, Lordship. Married, Lordship. Page 19, 20, Lordship. FIR.
What are the offenses registered?
Under section, Lordship, 341, punishment for wrongful restraint. And section 354, assault or criminal force to woman with intent to outrage of her modesty. 323, punishment for voluntary causing hurt. 332, voluntary causing hurt to deter public servant from his duty. And section, Lordship, 4, Lordship, of Arunachal Pradesh Protections of Medical Service Institutes Act 2019, Lordship. To that effect, Lordship, the compromises settlement is there, Lordship.
Will not allow this petition. How can this be compromised? You will attack a nurse in the night. You are a drug addict.
No, drug addict, Lordship.
Why do you want an injection without prescription?
No, Lordship. That prescription is there, Lordship. Prescription is there.
No. This either you will adjourn it or dismiss it. This is not the case. Maybe family dispute, you will attack a nurse in the night. There are the legislature has been compelled to bring legislation for protection of these doctors and nurse, and this will not allow. Will dismiss
Try
it.
my luck in other court, Lordship.
You try your luck in another court. We will not allow this. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 3 weeks. We will not liberal in all cases. When it impacts the society, unruly will not allow.
Yes.
Even husband, wife. 307 will beat mercilessly your wife, hospitalized, serious injuries, and then will come and compromise. No.
Slide.
Lordship, may I please? Joint petition, Lordship.
Where is the FIR?
FIR is in page number 22. 23 is the type copy.
22.
23. May I read, Lordship? Basically, the content of the FIR is the stolen of the gas cylinder back in 2012. Now the petitioner are all, they are grown up, they are having family. And also,
Now tell me, who are the petitioners?
petitioner are the two accused person and the third one is the victim complainant. They have mutually settled
Charge sheet file.
charge sheet file and pending before the learned judge.
Okay, tell me, where is the agreement?
Agreement is in page number 36 annexer 3. They have signed, the three petitioners have signed this agreement.
Yes, madam.
Pity of
Expose
Bangalore.
We'll get this order not today, but What is the date fix in that?
On Monday, we have fixed on JFC here in Divya.
Okay, Pierre, say that High Court has disposed of order will not.
Maybe on if Friday, on Friday, if I get
It is on Monday.
Monday coming.
Okay, we'll get it uploaded tomorrow. Not today.
Much obliged.
Okay.
Dispose of, give it to Nat or Haloi. Yes, Mr. Mazumdar.
Yes. My lord, we have filed an application under Order 7, Rule 11 for rejection of the petition.
Now, before that, have you decided not to come here or it is better to be present virtually?
My lord, if your lordship, I was also thinking because suddenly I was engaged at a very late stage. If your lordship desires, because this will take some time, I understand, my lord. I'll have to rely on some Germany. If your lordship is sitting next week also, then I'll move to Itanagar and physically remain present.
I am sitting next week. See, these are the important issues.
My lord.
Because if we appeal your contention, whole election petition goes.
My lord.
Isn't it?
Absolutely.
And if we do not accept your contention, then we
My
have to pass a reasoned judgment.
Proceed with the trial.
So that you can climb the upstairs.
Absolutely, my lord.
Isn't it? So these decisions are destined for the upstairs. Either way.
Correct. It appears. Yes.
So he is here. He is not having any difficulty. Can we take it on Monday?
Monday, I've got a little difficult. There's one matter here. Tuesday, possibly, I'll be in a better position if your lordship.
So if we take it on Tuesday,
my lord.
Tuesday and Wednesday, if necessary, we can continue also.
No, my lord, I'll take only maximum 2 hours. 1.5 hours, I'll be able to complete. 2 hours,
Okay.
I'm back.
So you will take 2 hours. He may take sometime 1 hour.
Yes.
Maybe. So 3 hours.
Absolutely.
So 3 hours judgment, the argument will require at least. So if you come on Tuesday, there will be some free time for me on 31st. So then we can try to deliver the order on reopening on 4th from Guwahati, because it will need some application of mine.
Yes, and I'm relying on a few judgments, my lord, because
so can you for today furnish the judgments? You can ask your
madam, we have made a spiral binding of all the judgments I'm relying, and we will just furnishing to your lordship.
Okay, give him a if possible copy or or otherwise the judgments.
Give the list of judgments.
Give the list of judgments. Okay. So you also go through. We are taking it up on Tuesday.
Obliged.
I'll also come prepared reading your files. What is because objection just I have not gone through. That will be a
True.
better way.
Even I have not seen the objection. I'm told just now that objection has been filed. I have prepared only on the basis of the IA.
So you also go through the objection. Let us prepare this weekend and let us get back on Tuesday.
Obliged.
Okay. On Tuesday, and thereafter we'll proceed. On Tuesday.
My lord.
Okay.
It will be better. Yes, my lord.
But what we'll do is we'll fix the other matters first, then we'll come back to you.
My submission and my prayer, subject to your lordship's ultimate decision. If in the morning hours we start, my lord, in the morning the zeal and strength remains different. In the evening, gradually we lose the morning hours. If your lordship,
that's correct. That's correct. We'll have a talk with the registry. We maybe ask them to list leisure matters.
But going by the nature, your lordship is disposing matters. Even after 2 o'clock, if your lordship takes up your regular matters, my lord, in 1 hour, your lordship will be able to complete those matters. And in the first half, we'll complete our election matters.
So you
And
want to,
that-
you want to sit me in the second half to take other matters, so that you can leave,
Well, no, not that, my lord. If necessary, I'll not leave, my lord. What I'm saying
so
is,
that you
my
can
lord,
leave.
strength-wise, my lord, first half, the strength remains different. One can argue with
Okay, we are not taking anything. We'll take in the first, we'll try to take in the
My-
first half
my-
only.
I'm
Okay.
deeply obliged, ma'am.
Okay.
Obliged.
You have filed the objection today?
No, yes, 22.
Okay. On the request of the parties, let this matter be listed on Tuesday next. I give the date. The date for consideration of the IA 188 AP 2024. Okay,
29th, my lord.
Obliged.
29th.
29. And you also
My-
give him the list so that he can,
Yes.
what will be your argument? Pleadings are there. If you want to rely on some judgment, you can also give it to us.
Okay, sure.
If possible, if may not be today, you can give it tomorrow and give with an advance copy to them. So that we come prepared and we do not waste too much of time.
Okay.
Absolutely.
Yes.
Deeply obliged, ma'am.
That's all.